afternoon. This is the Town of Hempstead Board of Appeals, September 17th, 2 p.m. hearing. Mr. Chairman, do you have any opening remarks?
I do. We seem to have quite an audience this afternoon. So I'm going to tell for those of you who have never appeared before us, the manner in which we conduct the hearings are as follows. First, we will call the calendar for any adjournments. If there are adjournments, we will handle those first, and then we will get into the calendar. Once we start calling cases that will not be adjourned, the protocol is the applicant makes their presentation up front. Then if there are any people who object, they will be heard. And finally, the applicant is given the opportunity to sum up, and then we will close the hearing. With respect to evidence, this is not a court of law, it's an administrative body, as a result of which we are not burdened by the strict rules of evidence. We will take almost any kind of evidence if it's reasonable. Emails, letters, etc. We do have a court reporter here, so all of the dialogue will be taken down. We would suggest that if you want to speak, wait until someone else is finished and speak clearly and relatively slowly so that she can get everything down. The proceedings are videotaped. They are archived so that you can refer to them in the future. Once the case is closed, we will not accept any additional evidence. Okay? Patrick, start calling the calendar.
Mr. Chairman, we have a few applications for adjournment today. First, we have case 51125, Wantagh Islamic Center of Nassau Incorporated. Use variance to maintain storage of commercial mechanical equipment in Residence B District with side and rear yard variances. Use variance to maintain storage of commercial trailer in Residence B District with side yard variance. Install 6-foot high fence forward of building lines on Oakfield Avenue, which may obstruct line of sight at neighbor's driveway, also known as 2856 Jerusalem Avenue.
Who's here on this case? Well, this is an application for an adjournment, folks. And every time, just about without exception, first time on, application for an adjournment will be granted. You are here on whose behalf?
The template, the mosque is my client.
Okay, so
We did not request the adjournment.
I know that. We just clarified that. We do have several letters from residents requesting an adjournment, and you're familiar with the protocol that we follow, are you not?
Yes.
Okay. So they want to obtain counsel, and as a result of the request, it being on the first time, we're going to accede to that request. And Patrick, when is the next date?
Chairman, a quick question.
Yes.
You're saying that you have certain residents. Where do they fall? Do they fall in that 300 radius, or are they just people that want to all town?
Hold on. Did you guys put your name and addresses on the record? Okay, I didn't hear it.
On that, no, they did not.
Oh, no, verbally, did you put them on the record? Both of you need to do that so we have it, because then it follows what you say.
For the record, architect Todd O'Connell, doing business at 1200 Veterans Highway, Hauppauge, New York.
For the record, Muhammad Ali, a trustee, Islamic Center of Nassau.
That's a good name.
Thank you. It's a great icebreaker.
It's a good name, right?
Yeah.
In answer to your question, Patrick, do we have the letters?
Mr. Ali, are you an attorney?
No, I'm not. I'm a physician.
Physician?
Yes.
What's your specialty?
I was in internal medicine, and now I'm in digital health and investment banking.
Okay. So,
Yes, it's great. Private equity is awesome.
Mr. Ali, I have before me a letter written by Robert Galgano, who was at Darby Road East. I am told that he is within the radius.
Can we see it on the map? Darby Road East. And I just want to just check, we have the radius map, so I just want to confirm.
That's not a.
'Cause I know you've been told that's within the radius, but I'd like to confirm it myself,
That he's.
because we also have the map.
Radius?
No.
No.
No. Anyone in the town of Hempstead.
Mm-hmm.
Because Darby Road is not here, so
Okay, so
that's not correct.
anyone within the town of Hempstead can request an adjournment.
Okay, so to clarify then, anyone in town of Hempstead can request an adjournment. So meaning there are other cases on this calendar, right, like today.
Right.
That means I can also just for kicks, right, just request adjournments. I'm not going to do that. I'm not going to do that because I respect the other members who come here for variances and things like that and not wasting time.
Probably so, but the people who live in this town
Yeah.
have standing to
Yeah, and so do,
possibly be affected.
I also
Oh,
have letters from congregants who attend our mosque.
Dr.
And
Ali, there's a reason why they're asked. They would like
they
to
need
get
time to
counsel.
get counsel.
Sure, no, absolutely, I completely get it.
You could
Okay.
come in if you're, another case in Valley Stream, for example. If
Understood.
you give the board a reasonable reason why you ask
On
for
the
an
first
adjournment.
time.
Understood. But I just wanted to clarify from a legal perspective that the chairman had previously said that they're in the radius, but now he's clarifying that it's the town of Hempstead. So I just wanted to make
He wasn't
sure.
referring to
Okay.
standing, he was just referring to most of the people who come here
Sure.
live closely and
Good enough.
have a lot to say.
No,
about
understood.
certain things.
By the way, I haven't gone through all the letters. I just picked one out at
Sure.
random.
Yeah.
Okay,
And could I know the other letters as well?
pardon?
Would it be possible to know who the other letters are from as well?
Do we
Since
have
the
the other
public.
letters?
Yeah, once we finish this, council, you can take it up with council to the board.
Okay, so it's, I
You
can't.
mean the public notes that came in? Is that what
I
you're
don't-
referring to?
Are those letters public? It's a matter of public record? Okay.
Who's what? Who's what? Apparently not. Patrick, well, that's.
So I went straight into digital health. I had an investment management background, private equity, so combined digital health and investment management together. So, yeah.
If my conversation with him bothers you, I'll stop.
What can you say, right? This is the type of things that we hear.
I understood.
I'm just missing the issue here.
Do you have the signage?
I don't. What is the issue here? I thought we received multiple requests for adjournment.
We didn't request an adjournment, other people.
No, I understand. The applicant did not. But one or more people in the neighborhood did. And as is standard practice, as you know, Mr. O'Connell, I've been here 20 years and I can't think of a time when we didn't grant the first adjournment.
Sure.
So,
I think his only concern was that if it was somebody that's not directly affected, that somebody within the radius would
oh,
be, the one.
no, you're correct. It's not, no, there's no secret that the people who usually show up and are more vocal are the people who are more closely connected, physically than 5 blocks away, but it's not uncommon. And again, standing is anyone who lives in the town. And I wonder if people couldn't argue if they live in the state, but whatever.
Theoretically, yeah, I agree.
Because the variances granted here and the relief sought here has precedential impact on the entire town.
Correct.
You could imagine though, it's less, it's hard for someone to point to a place,
Like in
6
Plum
miles away and
Lookout
say,
or.
yeah, they got a high house there, but we shouldn't get a high house here.
Correct.
Well,
But-
just for clarification, I understand there's been some confusion as to what you are here for today.
And by the way, that's confusion on other people's part. That's not confusion
Correct.
on the town or on our part.
Correct. I mean, you're here for a variance to maintain storage of commercial mechanical equipment in a Res B district,
Correct.
all right?
Correct. It's not my fault that there's
Absolutely.
people who are racist who think we're building
Got
some
it.
building.
Wait, what did
Just,
you say?
all right.
Did he say racist?
I mean, I can show proof of Facebook posts talking about Second Amendment. et cetera, so.
We're not a forum.
quite frankly, we're not familiar with those. I'm not familiar with
Sure.
those posts, and I would not. I'm going to defer to the
We can provide
calendar, and we'll give you the first date we can find it.
Absolutely.
Okay?
Thank you so much,
All
sir.
right?
Appreciate it.
You're welcome.
November 19th at 2 PM.
November 19th at 2 PM. For everyone here, you're not going to get another.
Wait a minute. Go ahead.
Oh,
Okay.
I take it
Tell
back.
us your first available date after that.
December 3rd.
Okay, there's not going to be another mailing to those of you here who are interested in this case. It's December 3rd. What time, Patrick?
2 PM.
Yeah.
2 PM. So make sure if you want to be here, that's the date. If you have other people who aren't here today and want to be here, you will not get a further notice. Patrick, do they have to update the sign? Mr. O'Connell, you know the drill. You got to update the sign.
Okay? You're welcome.
And let's not have hyperbole here, please.
No. Okay.
Tell O'Connell to put the place in, use the 350 front,
What?
this sign.
Mr. O'Connell? Patrick, one second. The chairman wants to speak.
Okay, so Mr. O'Connell, it's been brought to my attention that the sign that you did post had the old address on it, but now we are here, so if you could make arrangements to correct that, it would be appreciated.
And necessary.
Otherwise, we'll have a flock of people where we're not having a hearing. And it's much colder in that room than it is here. All right?
Yeah, right?
Thank you.
Yes.
Yes.
Same room.
2 PM.
Hold on, what? I'm sorry, who said that?
Said. Oh,
Hold on.
okay. Folks, this is a request for an adjournment that was made by the residents. We're granting that as we always do. We're not arguing the Second Amendment right now.
Wait, can we have Stephanie read it back?
Wait a minute.
Show their appearance here, would you please?
Stephanie can read it back.
Okay, that's all right. She'll take it. Because our meetings are from 9:30 in the morning until we finish. They are, no, we don't.
Well, we often go into the PM, yes.
Yes. I mean, we've stayed here as late as 10, 11 o'clock at night, midnight, as long as it takes. Okay?
The next application for adjournment is case 247 of 25, East Meadow, Jewish Heritage Center of Queens and Long Island, special exception for proposed religious use and religious education, waive off-street parking with insufficient maneuvering aisle and access driveway for two-way traffic with a special exception to park in Res B district and parking in the front yard setback, and with side yard variance, construct two-story building, demolish existing building, also known as 1440 Prospect Avenue.
Good afternoon, Mr. Chairman, members of the board. We've
That'd be a good idea, especially with the.
Good
cane
afternoon, Mr.
outside.
Chairman, members of the board. William Bonesso for Chelly Deegan Tarana, 333 Earl Ovington Boulevard, Uniondale, New York, here on behalf of the applicant.
And members of the board, I'm Kevin Walsh from the firm Walsh, Marcus, McDougall, and DeBellis, 229 7th Street, Garden City, New York. I represent neighbors who are objectants.
Are they close neighbors or
They're all with,
members of the town of Hempstead?
oh, they all are, yes, they all are, yes,
Okay.
yes.
All right, just to clarify.
Mr. Chairman, on behalf of my client, we're asking for an adjournment today. Last week, counsel for the objectors submitted a pretty extensive report, 17-page report that we're still reviewing and going over and preparing to address. So consequently, we are asking for the adjournment. I've spoken with Mr. Owens about an available date, and he's indicated that 2 p.m. on November 12th is available.
Is that correct?
Correct.
Okay, is that acceptable?
It is acceptable.
Okay, so we'll adjourn the case to November 12th, is it, Patrick? November 12th, 2 p.m.
Thank you.
You're welcome.
I'll talk to you. How was your trip?
Okay, we will be calling case 50525 through 50625, West Hempstead. Rachel Lessard, variance percentage of rear yard occupied, maintained pool, special exception to maintain second accessory structure, fire pit and bench, also known as 322 Garfield Avenue. Please raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address for the record.
I absolutely can. Sure. Good afternoon. I promise I'm not here to cause trouble. I'm sorry. You want me to? I'm sorry. I apologize. Understood. So the pool was, first I come in peace. That's for starters. The pool, I apologize. Michael Missoni Masonry, 182A East Shore Drive, Massapequa, New York. I am here in representation of Miss Rachel Lessard, 322 Garfield Avenue of West Hempstead. Good afternoon.
All right, you may proceed.
We are here today to ask for permission to maintain an existing 15 by 34 swimming pool in the rear yard of Miss Lessard's property, as well as a linear fire feature that accompanies a seating bench and an accessory structure, an outdoor barbecue that is noted on the plans as well.
Why is it called a linear fire feature? Because it's not round?
Correct. A little bit more modern.
Yeah. So it's in a straight line. Is it gas fired?
Yes, correct. It's actually a lot easier to maintain.
Okay. So you want to maintain the pool and these two accessory structure, or the second accessory structure, fire pit and bench, right?
That's correct.
And you need for that relief for this percentage of the rear yard occupied and a special exception So do you want to tell us about them or whatever we need to know about?
What is the percentage of the rear yard occupied?
So the percentage of the rear yard occupied, my question is, the pool counts as percentage occupancy, correct? Okay, so
Miss First?
No.
it is not.
Hold on.
Wait a minute.
Can Becky have a microphone, please? Stephanie, you'll know that it's Rebecca.
In reference to swimming pools, percentage of the rear yard is only the rear yard. So it would be the width of the lot time multiplied by 25 feet, which would be the determined rear yard. That area is then how much of the pool takes up that specific area only. And it's only that specific accessory structure, one at a time, not everything added together.
Wait, so you mean the fire pit and bench are not an issue as it relates to percentage of rear yard?
Correct.
Is it always only pools who do that? Or can it be other things depending on their location?
In reference to pools, it specifically states that that the accessory structure that the pool may not take up more than 40% of the rear yard.
You know, we rarely get that here before us.
Okay.
Each
So
municipality is
what
different.
percentage of the rear yard does this pool occupy?
Significantly less than 40%.
What percentage?
I would need my calculator to tell you that, if that's okay.
You can take
If
your
that were
phone
the-
out and use your calculator. It's
If you
not a
give me one
weapon.
moment, I'll figure it out.
If that
That's
were
all
the
it is,
case,
but it's
it's not a Second
not
Amendment issue.
today.
If that were the case, you wouldn't have been rejected for that issue. So whatever it is,
Yeah.
the building department is
Why are you
determined-
here?
Becky's doing it.
Yeah.
So the I was second or third contractor in on this project.
Fine.
Originally, there was a semi-in-ground pool there that was too close to the property line that we actually ripped out. She didn't have a permit for that structure.
Fine.
And when I found out that she didn't have any permits in place for everything, the pool was already built. So my permission granted is to maintain the pool as a part of my permit process. I did all of her outdoor hardscape and
Right, we
outdoor.
understand, but I think because you're here for the percentage of the rear yard the pool occupies, which is not a big deal necessarily, but when you said it doesn't occupy more than 40% of the rear yard, that confuses the issue. So
Okay.
we'll let Ms. First speak next and tell us.
The pool takes up 42.2% of the rear yard.
So it does. Okay.
Okay. Yeah, so we're gonna have to correct this. Where's the official? Hold on a second. Let's get the real one. Christina, Becky's did. Yeah, I just gotta find the one.
This is an above ground pool, but yeah. Yeah, to maintain.
So my calculations show less than that.
See, there it is.
That is because the way it's depicted on the site plan is not the way it is depicted on the actual construction drawings. The construction drawings state that the pool is 25 foot in length plus 8 feet for the spillover.
Wait, Ms. First, so you're saying,
So
The
the total pool is 33 by 16.
but wait, so we have two different sets of plans or site plans?
I have 15.
Okay, wait,
by
hold on.
34.
So wait, you're saying
Apologize.
these are the final plans on it? And you're saying those don't match the plans we're looking at?
It matches the plans, it's just, this is depicting incorrect. This says the 15 by 34 pool, but it's not adding the 8 feet for the spill.
Wait, it is or isn't correct? Because you said it is, but it's not having this.
It's just not showing the full dimension.
Where, on here?
Right, yeah, this is actually 34 by 16.
So it's not correct, we need to show the full dimension. Okay, hold on, we're gonna just get the documents corrected.
This is,
I don't think that's,
no, these.
oh, I'm sorry.
I'm sorry.
Yeah, that's from Andrew. It's not a problem. You're not documenting this 8 feet plus the.
Of course we are. The 34 is right here. It says 34 in there.
By 15, it's 34 by 16. So if you do 34 by 16, you get that dimension, divided by 1250 for the rear.
No, the pool's only 15 feet wide.
He's indicating here, the overall is 16. It's not taking into account.
No, the pool's only 15 foot wide.
It
It's,
has an indication of 16 here.
so he made a mistake on his, because he's the one that made the site drawings and.
Your
'cause-
auto cover, is that an auto cover?
Yes, but
It's
the auto,
included
since when?
since always. I've been here 30 years. And I do the public car payments. This gentleman just did this one. But the auto cover is included. And your 4 feet and your dimension here is into the auto cover. Even though it's in the wall, it's still included.
See, I've never, okay,
Always.
okay.
Okay, so with the auto cover.
Okay, so So I just learned something new today, apparently, that the town of Hempstead auto cover on the existing swimming pool counts as length of the pool. I've been building pools since I'm 15 years old. I had no idea about that, so that's on me.
So good. So now we agree, what percentage does it cover? 42 something.
42.
To be honest with you, we don't see the rear yard occupancy thing a whole lot either, and I've been here a long time. So,
This is my first, I believe. I don't
Yeah.
believe I've seen this.
I've been here going on 21 years and hold on. Stephanie, can you hear her?
When I usually do pool permits, I usually try to get them to move it closer to the house so we can get it out of the rear yard so we don't have to do a 40%.
Okay, now this one occupies what? She's our most experienced plans examiner of the place.
Listen, whatever I need to do, we're gonna do, obviously.
She came here in middle school. She's got more time here than me.
We're going to ask that you amend these plans to reflect the fact that it's 42.2% as
Wait,
opposed,
what's that number yet? Becky's
I
complete.
thought Becky said.
42.2%.
Okay, and 40 is allowable, right? So you're slightly over on the rear yard occupancy. Maintain pool, maintain. And for the record, you wish to maintain a
I
second.
apologize. What was the number?
42.2%.
Stephanie. So for the record, you also have a request for special exception to maintain the second accessory structure, which is the fire pit and the bench. And for that, you need no other relief, just the special exception.
That is correct.
Okay.
I'll have Christina deal with it. No, I mean, let him write on it. And if we need him to have it done with another person, she'll work it out to make it.
Manually corrected to reflect the corrected numbers, initialed and dated. Not
Jo-
plan.
Joanne's asking if he can.
Can he amend it since he didn't draw it?
Since he didn't do it, and if so, if that's not acceptable,
Yeah.
then will you make sure that you take
We can
steps
speak
to?
to Mr.
Okay, all
Bond.
right, okay.
Okay.
He can amend, Andrew's not going to.
Shh, you know Andrew well.
But if not, you'll do that, not in this way.
Okay.
So again, the only relief you need is that special exception to have the barbecue and the bench and this
Percentage of rear
somewhat de
yard
minimis
occupied.
percentage over in the rear yard.
Yes, please.
Anything
Okay.
else?
That is all.
Any other questions from the board?
I have a question. You said you were the third contractor in this pool?
Not in the pool, in the construction of the house itself.
And then you said you had 15 years' experience building pools, right? So then how do you not know that you needed a permit to build a pool in the backyard?
So there was an existing pool there already. I was told by previous general contractor who has since been kicked off the job that there was an existing pool permit for the pool that was there.
Which there wasn't.
Again, I had no idea. I was subcontracted in by him.
So, next time you're subcontracted in, you should check with the town to make sure there's a permit, because a pool is a dangerous thing, and
1,000%.
rules and regulations here,
I understand.
So it's just a point I wanted to make.
No, I totally respect it. Whenever I build a pool anywhere, I always do it with a permit. I was under the assumption that, this was a West Hempstead regular general contractor. I figured he had everything under control, and apparently that's why I'm here now.
Any other questions from the board? If not, do I have a motion?
Mr. Chairman, I would move that the hearing be closed, the matter be placed on the decision calendar. You'll be notified by mail of the board's decision once it's rendered.
Okay.
Second.
Thank you.
All in favor?
Aye.
Opposed?
Thank you so much. Have a great day.
Okay.
Next, we have case 50725 Franklin Square, Taco Bell of America LLC. Install animated menu board sign in conjunction with drive-through not permitted, also known as 596 Franklin Avenue. I do. State your name and address for the record.
Thank you. Good afternoon, Chairman, members of the board. My name is Eric Mine. I'm with Bowler, B-O-H-L-E-R. We're the civil engineer for the project here on behalf of the applicant Taco Bell.
Good afternoon.
Hi, I guess in the interest of time, I'll get right into it. Hopefully I can provide some simplicity flavor to the afternoon calendar here. We're simply here for a menu board at a Taco Bell restaurant in Franklin Square. The first piece of relief we're here for is for an additional detached sign. There is a monument sign out in front of the Taco Bell on the south side of the site, north of the southerly curb cut. So this, by definition, is a second detached sign.
Hold on, I do want to follow you along. So the first sign you refer to is?
If you look at the plan left is southerly, plan right is northerly. So the Taco Bell is the building on the southerly side of the site, and the menu board is at the rear of the building. There is a, sure.
Give me 1 second. So just so I know where you are, I see the one-story building. I see the arrows on north-south. And I see the queuing cars in that section.
Yes, the menu board is at vehicle 5 from the window.
Okay, that's a good way to describe it. There's your menu board. Now, 1 second. Miss First, how might you enlighten us?
Oh, I thought you were. I apologize.
Okay, so that's the menu board that is or is not the subject.
That's the subject.
So it's not there yet? Or it is?
I don't know. I haven't been to the site. They're about to open very soon.
When I go home this afternoon, because I only live about a half mile from here.
Sure.
Wait, it's a request to install it, but you don't know if it's already been installed?
All I know is they're trying to open very soon. I am here to try to get this menu board approved so that they can open up.
Okay, by that car with the notation proposed menu board, there's another seemingly sign there. What's that?
That is the apparatus that covers the menu board to protect you from rain. It was not considered a sign by the building department.
The way this is drawn, there is a, menu board with a space from that. There's another.
That's the speaker post. That's where the
speaker. Okay. And this says that it is an animated menu board. And how is it animated? I'm not sure it's a big deal because it's not near the traffic, but
Sure. Yeah, and just for the record, it is at the rear of the building. It faces the Starbucks to the north. It doesn't face the road. We're over 117 feet off the road.
Right.
But to address the animated portion of it, it's simply so that they can change the menu for the different day parts, as opposed to the old school where someone had to go out and open the sign cabinet and put the menu in and do that
it's
several times.
digital, and someone gets on a computer and says, it looks like this now, let's change it for the next.
Correct.
for
We
lunch
just
or
flipped
whatever.
from
Hold
breakfast
on.
to lunch.
She can't take us both down. So someone gets on it and says, okay, from now, whether it's for an hour or whatever, we want it to look like this. It's not that it's moving constantly.
Correct. It's not a changeable copy. It's just able to adjust the menu. Yeah.
Great, thank you. Wait, so what did they, why do they need this now? Why, wasn't this a part of their original application if it's necessary for the business?
From the time where the Taco Bell was permitted to now, they've made the adjustment from the more standard menu boards that were cabinet style to this. So being that it's a new store, they're trying to get this
So
menu
were they
board.
already approved for a sign there or a menu board there, just not animated, or they weren't approved for anything there yet?
No, so it's a little difficult. The entitlements were by the landlord. This was a landlord delivered site. And I believe the board got lost in the shuffle because sometimes the menu board is considered part and parcel to the special permit for the drive-through, which was granted. But now we're trying to legalize the sign because we become aware this is considered a sign, and therefore it's a second detached sign.
When did
So,
they expect to open?
Within a week or two.
That's how far along they are. That yeah, they finally got power a week or two ago. Yeah.
We approved this, if you recall.
No, I mean, how did they get this far without realizing they had to get to
And just to address that aspect too, the application, obviously, it takes a while to get on the calendar. So the application for it was filed, I think, 4 or 5 months ago. So yeah.
All right, any other questions from the board? If not, do I have a motion?
Move that the hearing be closed, the matter be placed on the decision calendar. You've been notified by mail of the board's decision once it's rendered.
Thank you very
Second.
much.
All in favor? Any opposed? Any abstentions?
Appreciate it.
Next, we have case 50825, Elmont Meacham 190 LLC, variances subdivision of lot area, front width from and on street line to front setback line, construct dwelling, lot A, existing dwelling demolished. Also known as 190 Meacham Avenue, as well as case 50925, Elmont Meacham 190 LLC, variances subdivision of lot area, front width from and on street line to front setback line, construct dwelling, lot B, west side Meacham Avenue, 205 feet north of Harold Avenue. Gentlemen, please stand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Take a seat, state your name and address for the record.
Greg Kalnitsky for Chelly Deegan Tarana, 333 Earl Ovington Boulevard, Uniondale, New York. Good afternoon, everyone.
It's Barry Nelson, 220 Pettit Avenue, Belmont, New York, 11710. Let me check that.
Okay, the property here is on Meacham Avenue, between Harold Avenue and Globe Avenue in Elmont. It's wholly within the Business X district. It's on a regularly shaped 80 by 80 parcel, which currently maintains 80 feet of frontage on Meacham Avenue. It is presently vacant, but was formerly improved with a single-family residence on an oversized parcel. And the property was previously the subject of a case before this board. That's case number 233 of 2023, wherein the applicant applied for a lot area variance to construct a two-family dwelling, and the board approved it. Conditions to that decision included no separate cellar entrance, no kitchen or cooking facilities other than the two kitchens that were proposed in the plans, that the basement cellar can't be used for cooking or sleeping, that there shall be no bathrooms other than those proposed pursuant to the plans submitted to the board, that there be no more than 2 electric meters, 2 gas meters, and 2 water meters. that the front lawn has to be maintained, and that the applicant had to install a blacktop driveway.
So what, that was a two-family that was granted on the 80 by 80?
Correct.
Okay. They demoed one house and proposed to put up a 1-2-family.
Correct.
Thank you.
That's why,
So,
You said two-family.
that's why I'm confused.
Just a minute. You propose to erect 2 one-family dwellings?
no, in 23, it was 1 2-family dwelling on the one lot. Yeah,
The new proposal is 2 one-family dwellings?
correct,
Without garages?
correct.
Without garages?
Without garages.
So, when the applicant didn't ultimately pursue construction of the 2-family home and opted to return here to ask the board for 2 single-family homes instead. So the application here is simply to subdivide the 80 by 80 lot into 2 40 by 80 lots and construct 2 single-family homes on that lot that was supposed to have a 2-family home on it. So the application is density neutral in that respect. The same property will be housing 2 families that was previously approved to house the 2 families. The reason for the application is that when estimating the cost of construction of the 2-family home versus the 2 single-family dwellings, it was determined to be a greater benefit to the applicant to construct the 2 single-family dwellings. And we would respectfully submit that because it's a density neutral application, that it wouldn't have any negative impact on the neighborhood and would have no impact on traffic and parking, and that the 2 structures would provide for better breezeways and sightlines from adjacent properties. So the 2 proposed single-family homes are 100% zoning compliant, but for certain lot variances required to make it a reality. And it was designed in that way. I know there was a comment made by Ms. D'Amato about the fact that there's no garages, but the properties, we wanted to ensure that the proposed plans did not trigger any further variances beyond those, for the lot that we need. The cars will be parked on a long driveway adjacent on the side yard of the houses. So the variances we do require today are for lot area and for front width from and on street line to front setback line, which I'll just refer to as frontage. Frontage.
Oh,
The frontage on the roadway. That's what it is.
So you provide 50 feet, and what should it be?
So it should be,
No, wait,
No,
Fif-
I think you're providing 40 feet.
right.
yes.
Oh.
Thank you, Joe.
Yeah, the requirement is 50. So, since we're in the Business X, that section of the building zone ordinance says that if you're building residential in the business zone, you need to comply with Residence C. So if you turn to Residence C, you'll see that there's a requirement that the lot has to be 6,000 square feet. We're proposing 4,000 square feet. And that same section requires at least 50 feet of frontage. We're proposing 40. So as will be more thoroughly explained by my colleague, Mr. Nelson, if the board were to grant this application, it would be consistent with prior decisions by this board. It would be consistent with the developed conditions of the neighborhood, and it would have no impact on property values in the neighborhood, or I should say no negative impact on property values. If you turn to the radius map of the application, you'll see that easily over half of the properties would not be compliant with lot size or lot frontage, and more likely something more like 70% of the properties on the radius map are in that developed condition.
Do we know how many of those structures are legal? Or no? I guess Mr. Nelson will get to that.
Yeah, he has a more thorough presentation on the character of the neighborhood than I do. But there's several decisions of the board I wanted to touch on that are included with Mr. Nelson's report, which, if it's not in front of you already, should be in front of you shortly. There's case 428 and 429 of 2006. That's at 168 Meacham Avenue and 167 Oakley Avenue, wherein the board approved a subdivision of a 40 by 160 parcel into 2 40 by 80 parcels, which are exactly the lot dimensions that we're requesting here. There's case number 104 and 105 of 2022, which is 1329 and 1333 Telegram Avenue, in very close proximity to the site, where the board approved a subdivision of a 65 by 80 parcel into two parcels of 26 by 80 and 39 by 80, both of which are smaller than the lot dimensions that we're proposing. There's also case 257 through 259 of 2023, which is 49 and 53 Evans Avenue, Elmont, where the board approved the subdivision of a 79 by 80 parcel into two parcels of 39 by 80, which is slightly smaller than the two 40 by 80 lots that we're proposing here.
Those have garages built into the homes, so do you know whether or not?
I didn't review those plans. I also don't recall seeing any parking variances applied for, so parking was accommodated on site, whether by garage or by driveway.
But I don't think we really do parking variances for houses. You know what I'm saying? Like, people don't come in and go, I want to build a house, and I only have one spot in my driveway instead of two.
Right. Well, the garage here could accommodate not the garage here, the driveway here could accommodate quite a number of vehicles for each of the single-family homes. And I think it would provide greater parking than the two-family that was originally approved by the board. We'd submit that the board's precedent would support the board's decision to grant if the board were inclined to make that decision. But to tell you more about the character of the neighborhood and the pattern of development, as well as the impact on property values, I'd like to ask Mr. Nelson to provide his presentation to the board.
Mr. Nelson,
Yes, sir.
you've been qualified as an expert in real estate for many times before this board. Since the last time you qualified as an expert, real estate expert, have any of your specs changed?
No, sir.
Okay, then you're free to testify as an expert in terms of real estate.
Thank you.
Welcome.
I handed in several exhibits, photographs of the subject property. They were taken by myself, and in my opinion, they fairly and accurately represent the subject property and the surrounding area that's found on Meacham Avenue and Oakley Avenue in the vicinity of the subject property. I handed in a booklet that'll include the cases that council just mentioned, the 4 subdivisions equal to or smaller than what is proposed in today's application. I also handed in comparable sales, and the last exhibit on 11 by 17 would be the subject block, Nassau County Department of Assessment tax map, section 32, block 560. And on that, I depicted the parcels that would be equal to the subject property in size, 40 by approximately 80 feet in depth. And you'll see I identified them in X's in a highlighted color and the street addresses. Council's gone over the case substantially. It was previously approved for a 1-2 family dwelling, and at that time, I don't believe the proposed or the approved 2-family consisted or had any garages. It just had on-site parking. In fact, that approval was for a 56 wide by 39.5 depth, and what's today is proposed is 2 single-family dwellings with approximately 25 feet in width and 42 foot in depth. So the lot coverage on each one is smaller than what was proposed for a 2-family dwelling. Going back to the pattern of development, area character, you'll see the parcel immediately to the north is a single-family dwelling, and it's on a similar parcel size as what's proposed to the subject property. Then you have a commercial building, 2-story masonry building, and then the next parcel is a single-family dwelling on a 40 by 80, and then a commercial property. Then you have 3 single-family dwellings on the west side of Meacham Avenue, each, and they would be known as 152, 156, and 160 Meacham Avenue, each 40 by 80 parcels. That pattern of development would be consistent with many of the parcels on the east side of Oakley Avenue in the subject block. The breakdown, as would identified on the Department of Assessment tax map in the subject block, there are 15 40 by 80s, 3,200 square feet, and one 45 by 80, 3,600 square feet. Back to the radius map, you'll see many of the parcels on the west side of Oakley Avenue, which is now getting into more of a residential area, as Meacham Avenue is business zone, both on the east and west side, so it has a lot of commercial and residential. It has two-family dwellings as well. Those parcels vary anywhere from 40 by 96, 97 foot in depth to some conforming 60 by 97 foot depths. The entire area character has a breakdown of 32, the radius map, 32 out of 35 parcels, and we would consider them all single-family dwellings, and there are two-family dwellings on less than 12,000 square feet in the area. 91% of the radius map is non-conforming, with approximately 70% equal to the proposed size of 40 by 80, 3,200 square feet. Council mentioned the cases that I've submitted, and there are, in the subject block, cases 428 and 429 of 2006, which would be 168 Meacham Avenue, just north of the subject property. It ran from street to street, where it was created 240 by 80 parcels back to back. That's in the subject block. The Meacham Avenue would be in the business zone. The Oakley Avenue is the residential C zone. The case that he mentioned on 1329 and 1333 Telegram Avenue, cases 104 and 105, which was a 65 by 80 divided into two parcels, a 26 by 80 and a 39 by 80. That block, that is just one block north, or it's the end of the radius map, just to the north of World Avenue. It's part of that section 32, block 70, and it's the first two parcels east of Meacham Avenue, east of the business zone, and I provided photographs for the board to review those two dwellings. Nevertheless, what's being asked for today's application, from a two-family down to two single-family dwellings, each on 32 by 80, 40 by 80, 3,200 square feet, is in keeping with many of the dwellings on Meacham Avenue in the subject block and in close proximity to subject property. A new home at that location, and I provided comparable sales, will sell in excess of $900,000 each, and in my opinion, fits well within the community as a residential single-family dwelling. Thank you. Yes.
$900,000?
I gave you comparable sale, yes, sir.
Wow.
Even if you went 875, you got up to 900. Yes.
Now,
yes, sir.
Next door to the south, that's a developed parcel, I assume.
Commercial, fully. I have provided photographs. It's a full two-story warehouse type building.
And that's owned by the same corporation?
No.
Is it?
Similar name, but it's, let counsel answer.
Well, no, it looks like a similar name, but it's not related to the principal of this corporation. It's not related.
Okay.
I think on Google it says it's clowns.com, but as Mr. Nelson said, it looks like some sort of a warehouse type structure.
Yes.
I'm sorry, I might have missed it. Why did the applicant decide, instead of this single two-family, to go for two one-families?
There's a greater benefit to the applicant when pricing it out, and I haven't just heard it from this client, but other builders often say that in this day and age, I mean, the big money items in the house are the plumbing and fixtures in the kitchens and bathrooms, such that, and you can't sell a two-family home for incrementally more than you can for the single-family home. I'll let Mr. Nelson testify to that since he's the expert, but they find it's much more cost-effective and there's a greater benefit to the applicant to develop 2 single-family homes instead of the 1 2-family.
Let me ask you, would your client, if the board were inclined to approve this, agree to a condition they be owner occupied?
Yes, I've had an opportunity to speak to the applicant about that, and if the board is inclined to impose an owner occupancy condition, they'll record the covenants and sell the property, and it'll thereafter be owner occupied.
They would agree to that.
Yes.
The next question is, you know, in looking at the floor plan, so now instead of a single structure with, let's say, a basement and 2 more levels, we're talking about 2 structures, none with garages, which from when I started on this board, that was just a non-starter. So now we're talking about 6 levels, right? And staircases that, I know you've been doing this a long time, as have you, Mr. Nelson, that not to say your client would misuse them, but lend themselves more easily to becoming a multifamily dwelling. For example, on this one, you walk in the first floor, there are stairs going to the cellar, stairs going to the first floor, stairs going up. So one thing that helps to mitigate the situation so that it doesn't lend itself so easily in the event your client, for example, sold it, would be to move the staircase to the other side so it's not near the door. Does that sound like something that your client would be willing to do?
The applicant and architect is right here. It's Mr. Wasim Hakim. So if you want to just give your name and address for the record and get sworn in.
Move the door over to this side. Right?
My name is Wasim Hakim at 73 Central Street, Woodmere, New York, 11598. I'm the applicant I'm the engineer of record on this application.
Engineer and applicant?
Yes.
Okay.
Yeah, and yeah, we can move the entrance to the other side. You have
Not the entrance.
or the staircase.
So that the stairs one uses to get to the cellar and the second floor are not near the entrance to the house.
Yeah, that's fine. We can
So I don't mean move the entrance with it. That would defeat the purpose.
Just move the door to the.
No.
No?
Keep the door over there, move the stairs over there.
That's what it would end up. Leave the stairs where they are.
and move the door here now.
No.
This is what we want to do.
Right.
The entire stair.
Right, okay.
That's all they want.
No, yeah.
Yeah.
Wouldn't this be the same thing?
If you move this, yeah.
Okay, yeah.
Yeah, that's fine.
Yeah, it's the same thing.
And you'll not put a door on the new relocated stair side?
No, the entrance will stay in the same place. The stair will move on the other side.
Right, okay.
Mr. Nelson,
Moving right along. How about a garage, interior garage?
If I could make just a small point about the garage.
Of course, it's your case, sir.
You know, people, I understand why boards want to encourage the use of garages, but the reality is people don't use garages for their cars. And I can share this tidbit with you because I'm just outside of the town of Hempstead. Not once have I had a car in my garage, period.
but assuming that's all correct, and I believe you, what they do use their garage for is storage of things. And if they don't have a garage to do that, then they're going to be back here with a giant shed or some other relief. So while I get I don't put my car in my garage anymore because I have my kids' snowboards, surfboards. But if I didn't have that garage, where am I putting all that stuff? And that's going to be a giant shed of some sort.
Well, there is a basement that could be used for storage. That's one option. But the benefit of not having a garage is if you're supposed to park your car in an open space, I see people use those spaces way, way more than I see people use garages.
Mr. Nelson, could you?
Look at this. It doesn't show on the plan. That's an extra.
Two things, Mr. Nelson. Did you give, I apologize if I missed it, you're thorough. what is the difference in the profit to the owner of the property if he builds a two-family dwelling and sells it, just the bare numbers, versus building two single families and sell it?
I didn't address that. A two-family at this location would sell for approximately $1,200,000 to $1,250,000. The profit on that would be about $300,000. The proposed single-family homes would sell for approximately $900,000, 900, or an aggregate of $1,800,000, and it would be a profit of about $450 plus to $500,000.
Give me the cost. Oh, I'm sorry, I'm wrong. And so the profit would be what?
About $500,000 on that one,
Total.
total.
Okay, now I noticed on the plot plan, it says, let me see if it's on both sides. On the rear entrance, it says new rear entry stair and stairs to cellar. Is there an exterior entrance to the cellar? Because I thought there wasn't.
There's an egress window indicated on the basement floor plans, which I've spoken to Mr. Hakim about. If the board doesn't want that egress,
That's not the
I
same
thought the
location.
egress was on the, yeah. The egress window's on the other side.
here, why don't you tell me? Ms. D'Amato, which page of the plans were you referring to?
Okay, as it relates to the notation about the cellar entrance, that I'm looking at SP 001.00101.
It's a site plan.
Dated 7/29/24.
We don't have it here. But there's no cellar entrance. This is the rear
I
entrance.
have no idea what you're saying.
There's no cellar entrance proposed.
Say it again?
There's no cellar entrance proposed. It says new rear,
New rear entry stair
The
and
first floor.
stairs to cellar.
no, there must be a typo there. There's no proposed
That's a
yet.
huge typo. No, he just said it's a typo.
Oh, it's a typo? You do see it though.
We don't have it in the floor plan.
Right.
You see that, Becky?
In any event, we're willing to accept the condition that there's no separate entrance to the cellar.
That's nice, but also it begs the question, like, that's an interesting accident that happened.
I mean, on the plan, on the disapproved plan, we don't,
I have no idea what he's saying. He's not speaking the mic.
I don't see what,
Yeah.
I don't think I have the same one.
it's not shown in here.
Let me see what this is.
No, he says no.
I have a composite here. Oh, I have a composite, I don't know what this is.
No, her composite in the back says rear entry stair. Here it is, right there.
New rear entry stairs to cellar.
Uh-oh.
No, in the plans, we didn't see it.
Well, your
Yeah, we can
section
adjust
also
this.
says.
Okay.
We can adjust that.
I'm getting old. You think I can read this stuff? Well, you know, make them write it bigger.
Okay.
Well, we need you to take care of this.
No, we don't need the cellar entrance. It's only the rear entrance to the first floor.
Okay. So just tell them it's not going to be a cellar entrance, only
Yeah.
entrance. Okay. So I've had an opportunity to speak with Mr. Hakeem. The intent is not to have a separate cellar entrance. He just wanted a secondary way of egress and access to the first floor. So
You can see on the plans, the egress is the other side.
Egress windows on the side of the dwelling.
Yeah. This is not that. This is something else.
She's talking about the egress window. We're not getting a window back there. This is just to the first floor.
yeah, if you look at the floor plans, that egress in the rear yard, you can only access the first floor from there.
Well,
Let's not mix it up. The egress window has nothing to do with this designation on this plot plan of a cellar entrance. That egress window is on the left rear side, which is on the side. This cellar entrance language is unrelated to that egress window.
Mr. Nelson, maybe you could help them out?
No, we don't need it.
What we can do is change the notation to first floor only.
And that's a sliding door.
Right, it's a sliding door in the rear, and if you look at the floor plans for the first floor, it's clearly intended just to access the first floor. I'm not sure why it was notated that way on the composite.
It'll be amended.
We can amend it and change the notation, but there's otherwise no entrance to the cellar from there. Right, and we will absolutely change the notation and fix that. Okay. We're happy to submit revised plans, as I said, eliminating the inaccurate notation and affirmatively demonstrating that there will be no cellar access from the rear or anywhere else. You're going to have to go into the main entrances to access the cellar. I think we intend on building exactly what's in the plans, so we could, if you want us to record a condition in the covenants and restrictions to that effect, we can do that as well. All right. Does the board have any other questions?
Any other questions from the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Everyone who signed in on the case will receive a copy of the board's decision by mail once it's rendered.
Second?
Second.
All in favor?
Aye.
Any opposed?
Thank you.
Yep.
Next, we have case 51025, East Meadow Catch Air Incorporated. Special exception to use portion of existing building for public assembly and amusement, proposed indoor kids play center, also known as 1900 through 1980 Hempstead Turnpike.
Gentlemen, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God?
Patrick, could this young man sign in, please?
I went through this already with Albert.
Yeah.
I gave up. What is this? Oh. I don't know.
Good afternoon, Mr. Chairman, members of the board. William Bonesso for Cheli Deegan Tarana, 333 Earl Ovington Boulevard, Uniondale, New York, here on behalf of the applicant Catch Air Inc., Seated to my right is Mr. Michael Perkowski. He is a representative of the property owner, Regency Centers. They own this property, what was formerly known as the East Meadow Plaza. They also own the Stu Leonard Shopping Center to the south. And if the board recalls, back in February, we heard a much larger application before this board to basically unify the two shopping centers with a driveway that connects the two. That covered a lot of ground. Not only did it obtain required parking variances for the proposed new uses, including this one, because this was already contemplated and calculated as a place of amusement in the zone, in the parking calculations for the center, but it also accounted for certain areas where they were going to have restaurants, drive-throughs, outdoor dining, and the like. What's before the board today is simply a special exception for a place of assembly and amusement associated with what is a children's gym and indoor play center. This board has heard me preach on a number of occasions about these types of uses, how important, certainly I believe it is, that we get kids away from screens and video games and the like and get them to be playing, interacting, having actual physical activity, interacting with human beings, and doing so in safe locations and facilities. And this is just that. I've handed up a set of renderings showing the floor plans and some of the items associated with the play center. I've also submitted a flyer that relates to birthday parties, which I'll get into in a moment. But this is intended to be a children's play center. It is an indoor play center that is really geared towards children ages 10 and under. Doesn't mean that parents can't bring in a 12-year-old if their 10 and 8-year-olds are there as well, but based on the design, it really is not going to keep the interest of kids over 10 years of age. There is also a separate toddler area for 4 and under. And again, if a parent is with their 10-year-old and their 3-year-old and they want to be together on the floor playing in the non-toddler area, they can, but nobody over the age of 4 will be permitted in the toddler areas. That's strictly for 4 and under. This company, this will be the first Catch Air on Long Island. They also are looking at a site in Massapequa, but this will be the first one. It will introduce this type of activity. They typically have 2 themes. The one you see on the renderings before you is for the outer space theme. They also have an under the sea theme, and it's really geared towards, like I said, 10 years and below. They work presently on walk-ins and on reserved birthday parties. Their hours of operation are proposed to be Sunday through Wednesday, 10 a.m. to 7 p.m., Thursday through Saturday, 10 a.m. to 8 p.m. The way it works is literally for a walk-in, parent will come with their children. They sign them up for a certain amount of time to play. They can either go in with their children and play with them, or there is a mezzanine where they can sit, and it's basically an observation area. They can just watch the kids while they're up there. They do have some centers outside of New York that have memberships. They are not planning on implementing that here at the present time. They're going to open up strictly as a walk-in center and also as a birthday party, reserved birthday party center. In terms of staffing, they expect to hire 15 to 25 people overall. During weekdays, they'll probably have 3 to 4 people present. They have far less activity, particularly during the school year. They have far less activity when kids are in school. But then on the weekends, they would have probably 10 to 12 staff present. The operation, as I mentioned, you walk in the front door, you sign in. Children are stamped, their hands are stamped. If there are more than one child from a family, they get unique stamps for security purposes so that they're only leaving with the parents that they came in with, and they're leaving together. They do have, like I said, with regard to birthday parties, those are reserved in advance. And they have 3 party rooms that could be occupied at the same time for about 20 children. Those are booked for 2-hour periods, and most of the time they'll occur on Saturdays and Sundays. The 2-hour period equates to basically 80 minutes of the kids on the floor playing with the various on the various entertainments and play areas, and then 40 minutes inside the room where they'll have their food and their birthday cake or whatever kind of refreshments they're providing. There is a kitchen on site, but it's strictly for warming and by catch air. People are not allowed to bring in their own food other than birthday cakes. If they're going to have a party and they're going to have food there, they will buy it from Catch Air. Catch Air has a limited set of offerings like pizza, hot dogs, French fries, chicken fingers, things like that. Pardon?
Cook it there, or they have?
They heat it there, yes. They defrost it and heat it there.
They're a nut-free facility, so that's the only way for them to, they're a nut-free facility, so it's the only way for them to kind of control.
To make sure that nobody comes in and brings in.
If I want a pizza and I'm having a party, I have to get it from them. Are they actually preparing the pizza?
Yes.
Frozen pizza.
Someone and heating it up.
It's a frozen pizza. They have a party attendant assigned to each party, at least one member. Sometimes if it's a big party, they might have 2 members. That party attendant will set up the tables, will prepare the food, will serve the food, will assist with the party. They also provide, you can bring your own party favors and party plates and hats and things like that, or you can buy them from Catch Air and they'll provide them. But if you have a specific theme, you want to do
I wanted to get an understanding of the degree to which the cooking is.
Cooking is handled only by the heat. The reheating is handled only by Catch Air.
Is it cooking or reheating?
It's reheating.
You just have a stove or two and a microwave or two.
Correct. It's
microwaves and those ovens that they, like, Subway, that the quick heating convection ovens, but no frying, nothing of that sort.
No need for grease traps or anything like that. This is not a restaurant kitchen. It's not a professional kitchen. It's really a reheating kitchen.
And some refrigerators for sodas or waters.
Yes, they have refrigerated areas because they get deliveries once a week of their food. That typically occurs once a week on Thursdays. It takes about 20 to 30 minutes for the delivery to take place. They happen during business hours, but typically during the week when it's not as busy as the weekend. Those are handled via box trucks or vans. There will be access to the space in question from the rear of the building, so it doesn't conflict with parking in the main parking lot where customers are. And then they have a beverage delivery, Coca-Cola products. That happens once a week, typically on a Monday or a Tuesday. Same thing. That one takes about 10 minutes for the delivery. It occurs again from the back, will not interfere with the vehicles that are parking for customers in the front. They have no outside, as I indicated, they have no outside food permitted other than birthday cakes or the sweets that are associated with the party, and the party supplies are available. There's a very limited retail aspect to the business. They basically have 2 things available. Children who go into the play area have to remove their shoes, and if they don't have socks, they have socks that they can sell. You must wear socks in the play areas, so if they don't have socks, they can sell the parents' socks, otherwise they're not permitted in. And they also have some small amount of stuffed animals that they sell at the front desk as well. Other than that, there's no other retail activity associated with the project. Their refuse pickup is private pickup through the landlord. It'll be again through the back. They'll have access to receptacles back there where they'll store their garbage, and it'll be taken by the same company that is servicing the entire shopping center. So all in all, it's another play area. There are a couple of different children's activity centers that are being added to this shopping center. This is one that's taking up quite a good size space. How big is the space?
It's
about
15,000.
15,000 square feet. And as you can see from the layout, it's a pretty involved layout for the kids to run around and play in. And again, this is, again, in my limited opinion, something that's very important these days to get kids out and playing and interacting with each other as opposed to looking at screens or playing on social media. So that's our direct presentation. If the board has any questions, we're happy to answer.
You two folks, you're here for this case or just?
No, I'm just learning.
Learning. So am I. Sarah, please sing. If you wanted to get a notice, you'd have to sign it, that's all. Suggested.
So you don't, there are no Star Wars themed exhibits with the original lightsaber that was just sold for $3.6 million. Darth Vader's lightsaber.
I can tell you if there was, my son would be there. My 34-year-old son would be there.
He'd have to fight me for it.
He's a huge Star Wars fan.
As am I.
One of his good friends just gave him the Lego Death Star set up, which is something, I don't know, 12,000 pieces or something like that.
$1,000.
$1,000, and it's like 12,000 little pieces. So I don't know. He hasn't found the time to start it yet because he's got a 2-year-old at home. So that comes first.
I have several of the original posters for the Star Wars movies, one of which didn't have a title yet. It came out before the title was given to it.
Well, my wife is an aficionado too, and I'm sure you've been in Mr. Owens's office where he has quite a few Lego Star Wars helmets. Is that correct, Mr. Owens? Thank you.
Okay.
So you admit that?
Any other questions from the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Mr. Benesso, you and your client will be notified by mail of the board's decision once it's rendered.
Second. All in favor? Any opposed? Okay, I believe that concludes the afternoon calendar. We are going to take a 10-minute break, and we will then come back and do decisions.
Stephanie, before you clean up, I want to ask you something.
Mr. Benesso. 505 and 506 of 2025 West Hempstead, Rachel Lessard. Variance percentage of rear yard occupied, maintained pool, special exception to maintain second accessory structure, a fire pit and a bench. Have any questions from the board? If not, do I have a motion?
I have a motion, 505 of 25, 506 of 25, West Hempstead, Rachel Hazard, variance, maintain pool, special exception for second accessory structure be granted as requested.
Second,
Seconded.
pool conditions. You need pool conditions on this?
We could do pool conditions.
Pool conditions.
Aye.
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 With the drive-through. That's in 596 Franklin Avenue and Franklin Square. Do I have any comments from the board? If not, do I have a motion?
I move 50725 Taco Bell, 5-year conditions and granted.
Sorry. Okay.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? 508 and 509.
I'd like to
Elmont.
hold that so one or more of us can look at it.
I think we're holding it for amended plans. Well, they were going to amend their plans, I believe, to remove the notation, cellar entrance, and also to move the staircase and the door.
Yeah, I think there were a number of things that we should hold it for.
But on, I understand holding it, but on the basis of the area, that's what's there.
That's okay.
These houses that are pretty dilapidated on.
Right, but the lot size wasn't so common among that street. On the other street, more so, but
All right, we're going to hold it. All
given
right.
the issues that were raised in terms of the accuracy of what was said compared to what was on the paper, that's what.
510 of 2025 East Meadow, Catch Air Inc. Any discussion? If not, do I have a motion? Oh, wait, we need a secret determination.
Okay, so I move that we adopt a negative declaration as to the secret determination based on the testimony given, exhibits in the file, and other materials we've reviewed and analyzed.
Second?
Second.
All in favor?
Aye.
Okay, now a motion on the
I
application.
make a motion of case 510 of 25 East Meadow, Catch Air Inc., located at 1900 to 1980 Hempstead Turnpike, be approved as requested.
Second?
Second.
All in favor?
Aye.
Any opposed? You got a couple of conditions on there, no cooking on the premises, only warming, hours, maybe 1 hour too.
Mr. Chairman, may I
Yes.
just mention, as it relates to the next case, which has been adjourned, the remarks made unsolicited by one or more of the folks in this auditorium today, or the courtroom, leads me to think that you might, when we do revisit this case in this courtroom, you may need to, set some ground rules so that people aren't just, out of nowhere making inflammatory remarks, because otherwise we're going to have to repeatedly adjourn this case on the basis that we can't keep everyone here if there's infighting and, discord and chaos.
Point taken.
Thank you.
All right, that's 511 of 2025, which has been adjourned to December 3rd at 2 p.m. And then we have 247 of 2025, East Meadow, Jewish Heritage Center of Queens and Long Island. That case has been adjourned to November 12th at 2 p.m.
There's two cases.
Yes, so you asked for
25 Saratoga and 6 Woodhill.
that, just,
Second? All in favor? Okay,
We good?
have a nice holiday.
All right, y'all. Enjoy.
Thank you.
Patrick, don't leave.